Welcome to the Learning Center of the Companies Act 2013. First of all, we will learn about the basic of a company and what are the nature of the company. Some of the point I hope that you have learned at your school level or at the graduation level. Basic of a Companies Act is very important, because every time you will find at least one question, whether small or a medium size, varying from a 2 to 6 marks from this discussion, right? Let us understand Companies Act 2013. First, a meaning of a company and introduction. Now in this segment, we will learn what is the meaning of the word company, what is the definition of a company, what are the basic character of the nature or features of the company. First of all, definition. Question is that whether the word company is defined under the Companies Act 2013? Yes, my dear friends, the word company is defined under the Companies Act 2013. Section 2, clause 20. Define the word company as under. Company means an association of the person registered under this act or earlier act. Now this definition does not provide the much clarity. This act means the act of 2013 and earlier act means the act of 1956 or any other act earlier than the 1956 act. So company may be registered under any of this act, but registration of the company is a compulsory, necessary. From the definition, we can conclude only the one point, that registration of the company is compulsory. So you will ask me, sir, registration of the company is compulsory, but where? Company is required to be registered as per the Companies Act with the registrar of a company. Now onwards, I will call it as ROC, registrar of a company. Same way, you can write in an exam also. ROC is available with every state. So in each state you will find the office of a ROC. Nowadays, the person who would like to start a company do not require to visit physically the ROC office, but they may apply online on the website of mca.gov.in, right? Now this website is providing all the facility for incorporation of a company, right? So company means company registered under this act or any other earlier act. Company in India is not possible without the registration. Now this is a technical language. If somebody would like to understand the meaning of the word company in a very easy way, then would like to say company means in a very easy way, that means in a layman language. Company means an association of the person. Company means an association of the person with the objective of earning the money or profit. And remember, my dear friend, whenever I am saying association of the person, there should be at least 2 or more than 2 persons needed. So company is possible only with at least 2 people or 2 persons or more than 2 persons, right? Now, company means company registered under this act. This act means Indian Companies Act. That means a Companies Act 2013. So what we are talking here is an Indian company, right? The foreign company means a company which is registered outside the India. Now you will ask me, sir, Is there any other term defined under the Companies Act 2013 very similar to the company? Yes. One is a word company, and at the same time another word body corporate is also defined under the Companies Act 2013. What is the difference between the company and body corporate? Let me explain in a very simple language. Every company is included within the meaning of the word body corporate, because a body corporate includes any company, and company means Indian company, right? So here any company means it includes the Indian company, it includes the foreign company, it also includes the bank, it also includes the financial institution. So body corporate is a very large word, wider meaning word, and it includes every kind of a company. But when I am saying simply a company, we mean an Indian company, so the company is a narrow term. So all the company is included in a body corporate, but all the body corporate may or may not be a company. So let us understand the definition of the word body corporate. Body corporate includes any type of a company, any kind of a company, but it does not include following two categories of the organization. Number one, cooperative society. Because for them there is a separate act. They are governed under the separate act. Even though there is an association of the person, it is not regarded as a body corporate. And any other corporation or a body corporate exempted by the central government, right? So the word body corporate is a very large and wider meaning, while the company is having a narrow meaning, right? Whenever the Companies Act use the word company, the provision is applicable to the Indian company. But whenever the Companies Act use the word body corporate, the provision is applicable to all, whether it is an Indian company, foreign company, bank, or a financial institution, right? Let us move and learn the nature or features of the company, right? We know that the company is required to be registered with the registrar of a company, and therefore the company is known as an artificial person, because the company has been given a recognition by the process of registration. The company is given the birth, the company is given the recognition by issue of the certificate. The certificate is issued by the authority, right? Point number two, company is a separate legal entity. Separate from whom? Remember, we know that in the case of a company, the management of the company and the shareholders are separate. Shareholders are not involved into the day-to-day management of the company, right? So in a way, the company is a separate legal entity. And for the purpose of separate legal entity, we are having a two landmark judgment. One is a Solomon versus Solomon and Company Limited. Let us understand what was the fact of this landmark judgment. The judgment belongs to the UK, right? United Kingdom. Solomon was a shoe merchant. One day he get an idea that let me start the company and sell my business to the company. In fact, he was doing the business in a proprietorship form, right? So he started the company, Solomon and Company Limited, transferred his business along with the asset and liability to this company. For this purpose, the company has allotted the Solomon, his wife and his 4 sons the majority of the shares. Company was doing the business. After 6 months, the company was in the need of the finance or a fund. So the management of the company approached the Solomon. Can you provide us a loan? Solomon said yes, but what is a guarantee of a repayment? So the scheme was prepared between the management and the Solomon that the company will issue the debenture. Debenture will be a secured debenture. Solomon will provide a loan to the company. Accordingly, the transaction has taken place. The debenture, secured debenture were issued. Now, after some time, the company went into the liquidation. At that time, Solomon was a secured debenture holder, secured creditor. There were other trade creditors also. They were unsecured. They represented before the court that Solomon and the company are same and one because Solomon and his family are holding the majority of the shares. And therefore, money should be paid first to us and then after to the Solomon. But the court has held that shareholder is not the owner of the company because a company is a separate legal entity. Applying this rule, the money should be paid first to the secured creditor, and here Solomon is a secured creditor, so he is entitled to get the money first. So there was a first judgment on the basis of the concept of a separate legal entity. In the same manner, there is another judgment, Lee versus Lee Air Farming Limited. A very similar judgment on the separate legal entity where the Lee was qualified retired pilot. One day he got an idea to start the company. He started the company and he was holding the 99% shares of a company. The main objective of the company was to fly the plane and help the farmers, right? And to take the charge for that. Now, as Lee was holding the 99% shares of a company, Lee appointed himself as a managing director of a company. Lee was only the qualified pilot, know how to fly the plane, so he appointed himself as a chief pilot of the company. In the UK, the labor law are very strange, very tough. And it says that whenever you employ anyone, you are required to take the insurance on the life of the employee. So the company has taken the insurance on the life of a Lee. While one day the Lee was flying the plane, it crashed, died on the spot, and his widow claimed the compensation from the insurance company. Insurance company denied that how the one person can be an MD and the qualified pilot. Because an MD is the owner of the company, pilot is an employee of a company, and therefore we are not supposed to pay the compensation. But the court explained that MD of a company is not the owner of the company because the company is separate legal entity. And thereupon the court has ordered the insurance company to pay the compensation to the wife of Mr. Lee. So company is a separate legal entity from everyone, from a shareholder, from a management, from a directors, etc. And I think it is the biggest advantage of the company format of a business. Here I am doing the star mark. Star means important, right? The third nature or features of the company is that the company is having a limited liability. Company is having a limited liability up to the value of the asset. And not only that, the members of the company do also have a limited liability. This liability is limited up to the unpaid amount of the shares held by them. The fourth point is that every company is having a perpetual succession. Perpetual means continuous. So if, say for example, the person who are the members of the company dies, his legal representative will become a member of the company, and by this method the existence of the company will be continued, right? Like in accounting, you people recognize as an ongoing concern, right? Company, being a separate legal entity, can hold the property in its name. Company is having a right to purchase the property, right to use the property, right to protect the property. Now, company, where the capital of a company is created or raised by issue of shares. Now the shares are transferable. Again, this is one of the fantastic feature of the company format of business. Say for example, I invested into the capital or a shares of a company, and after some time I don't want to have the continuation of a shares. I can transfer it to the somebody else and get my money back, right? So the shares can be transferred as per the method provided under the Companies Act and as per the provision of the article. Now we know that company is an artificial person. Company do not have a physical organ, like I am having a hand, you are having a mind, etc. So therefore, who will sign the documents, contract, agreement on behalf of the company? So the people found out the way the company should have a common seal. The common seal is like the rubber stamp, but not exactly the rubber stamp. It is a way of authenticate the document of the company, right? And usually the common seal is made up of a metal of a round shape, right? Where you will find the name of a company, right? And remember, the common seal is not to be affixed on all the documents. The common seal is to be affixed only on a certain documents. Contract, power of attorney, share certificate, share warrant, etc. And common seal is required to be kept into the custody of any person who has been authorized by the board of directors in this regard. The next important feature of the company is that being a separate legal entity, company can sue. Sue means appeal or a complaint, or be sued. That means if somebody has done something wrong, company can complain in its own name. And if somebody else has done a wrong, company can apply in its name against that person. Combinedly, we would like to say the company is having a capacity of a sue and be sued by the others. And remember, the company is an artificial person. Being an artificial person, there won't be a death. Death is only possible in the case of a natural person. In the case of a company, there will be a winding up. Winding up is what? To close down the business, and existence, legal existence of the company will be erased or removed, right? So these are the features of the company. We can also compare the company and the partnership. Partnership is one of the old method of doing the business. The main difference between the company and the partnership is that company and the member of a company have a limited liability, while the partnership firm do have an unlimited liability. Company is more recognized format of business, while partnership is the traditional form of the business, old form of a business. In the case of a company, registration of the company is necessary. But in the case of a partnership firm, the registration of the firm is optional. In the case of a partnership firm, there won't be a concept of a perpetual existence. But in the case of a company, there is a possibility of a perpetual existence. So, in a way, if I compare the company and the partnership firm, the company is a better format of the business as compared to the partnership firm. You may now note down the points, and then we will go to the next point.